Good afternoon, everyone. Welcome to our third and last panel for the first day of our conference. Under normal circumstances, this would be the one just before the nicest part of every conference, meaning going for a dinner. But since due to the lockdown in Austria, it is not just all the restaurants are closed, but also travel. There are some limitations on travel, and therefore our experts were not able to travel to Vienna. So we need to stick to this online platform. To all of you, to those of you who switched on now, just to remind you that this conference, due to this unusual circumstances, we are organizing this as a two-day event. But unlike the regular schedule when the two-day conferences are on the two consecutive days, this two-day conference will be held on two consecutive Fridays. So we are meeting today on this Friday for the online session, or three sessions actually, and then next Friday, exactly 1 week from now, we hope and very much look forward to meeting physically on site here in Vienna at the premises of Polish Academy of Sciences. And if the COVID situation does not deteriorate during this 1 week, we hope to be able to hold the meeting physically on site. Having said this, please let me welcome our speakers. I will have the privilege of chairing this session. So please let me start with brief introduction of our panelists today for this session, and then I will hand over to our speaker. So this session happens to be Italian-Polish meeting, but I'm certain we will have many comparative observations as well. So we will not just remain in this Polish-Italian company. We have four speakers, but we will have three presentations. One of them will be delivered jointly by Valentina Allotti and Federico Raffaele, my good Italian friends. Just to mention that a few years ago, I think now it is 3 years ago, there was a nice conference hosted by Luis Guido Carli University in Rome, which is also a member of CECL network, that is the umbrella organization, and under the aegis of CECL, this conference is also held. So we still remember this very nice conference in Rome. We are now in Vienna. So to introduce our first speakers, Valentina is a senior legal policy officer at Assonime, which is the Italian Association of Joint Stock Companies. She works in a unit that is responsible for capital market and listed companies. She's specialized in company law, securities, market regulation, and dispute resolution, with a particular focus on the European law. She is the contact point and the voice that speaks on behalf of the association in all the issues, policy issues. She is responsible for drawing up position papers, policy briefs, and other responses to whatever consultation processes that are launched by the European Commission. And as we know, this is the way European law is produced. She is also vice president of the Italian Association for Arbitration, where she coordinates the focus group on corporate arbitration. She is also a member of ICC International Committee on Arbitration. Furthermore, she is a member of the Policy Committee of European Issuers, where she chairs the working group on company law. And also she is a member of Smaller Issuer Committee there. She is also a member of CEG Corporate Events Group at the AMI CECL. And when it comes to academia, she holds a PhD in comparative law. And as I mentioned a few years back, she was involved also in organizing one of the conferences in the series. Federico Raffaele, I'm honored to call myself a long year now friend of Federico. Every July, he is the host of a very renowned summer school that is held at Luis Guido Carli University in Rome on company law and capital market. Federico is adjunct professor at the very university, Luis Guido Carli. He is also vice president of the Harvard Law School Association of Europe, and he is now in-house lawyer, head of legal finance and M&A at Team Società per Azioni, which is the Telecom Italia, as I understand, the biggest telecom company in Italy. Before, she has a long year experience as a lawyer, also working for numerous law firms. She graduated both from law and economics, which is a very useful combination. She holds an LLM from Harvard Law School, where she was active during his time, serving, among others, as research assistant to Professor, very famous Professor Mark Rowe, and also as editor for the Harvard Business Law Review. His PhD is from Louis Guido Carli University, when she also was a postdoc fellow specializing in corporate law. Now, turning to our speakers from Poland, connecting from Kraków, my colleague, Dr. Maciej Durbas, who is a practicing attorney of counsel at the law firm that I also have the honor to work with, Kubaskos-Gałkowski, based in Kraków, also with office in Warsaw. Maciej is an expert in the field of dispute resolution, has significant experience in arbitration, serving as counsel, but also arbitrator, or also secretary of the arbitrary tribunal. His field of expertise covers many fields. Company law obviously is among those. He is also a member of the Chartered Institute of Arbitrators, and what I highly appreciate, Maciej for a long time and successfully has coached students of the Jagiellonian University in Kraków who take part successfully, as mentioned, in moot courts. Maciej, I'm very glad that you accepted our invitation. And another long-year friend of us, Dr. Krzysztof Grabowski, who is a legendary figure at the Polish capital market, one of the first people who was given the license of the broker. So he is established expert on the capital market, that he witnessed the development of the Polish capital market from its very beginning in the early 90s. He is also affiliated with Other Hand Institute, where we work together on many conferences in Poland and abroad. He is also very active in European level. It could take me too long time to mention all his affiliations and works, but at least one thing I want to emphasize: he is a member and expert of the group on technical aspects of corporate governance that works under the mandate of the European Commission. So he has a direct influence on the European lawmaking directly at the level of the European Commission as an expert advising to the European Commission. But the capacity in which I think most of the knowledge that Krzysztof will be sharing with us, he is one of the key figures on the expert witness market in Poland, with a very rich experience of delivering expert opinions to the courts on various aspects of financial instruments and other very technical issues. And I think he is the best example to share with us his experience of how blurred might be the line between what pertains to the law and what is this very special expert knowledge, as those two tend to overlap. But if it would not be enough to praise Krzysztof, he is unique in any company in this group. If at any conference that brings together lawyers and economists, Krzysztof graduated in chemistry. So a very unusual background for an expert in financial regulations, but after a couple of decades of hands-on experience with the Polish capital market, this is just an anecdote for the most of his professional life. He has been working on the capital market and looked at this from very, very different angles. So I'm very glad, Krzysztof, you also accepted our invitation. And well, having introduced our experts, please let me now give the floor to our Italian friends who will now speak on arbitration, but not just on arbitration, because this conference is not purely devoted to arbitration. There have been many conferences on arbitrating corporate disputes, but since specialized courts face a very natural competition in arbitrators, we look what lessons can be learned and how this competition can look like in the future. Valentina, Federico, floor is yours. Floor is yours, please.
Thank you, Arek. Thank you for inviting us, and thank you, thanks to the organization for having has us, although not in person, which is such a pity. But anyway, we're trying to enjoy the conference. We have already enjoyed the conference this morning, and we're trying to enjoy the rest of it. Yeah, I mean, what you just said is what we felt when we first thought of how to take part into this conference. We thought that the game might be which one doesn't belong, right? So we would have raised our hand because we would be speaking about arbitration in a conference devoted to the topic of specialized courts. That might not be the right arena where to speak about arbitration. But as you said, I mean, what we are actually focusing on is a purely Italian perspective, from which we are going to derive and make a case for a European approach. So we're trying to, let's say, to sketch out some of the concern we have with Italian regulation, and we're trying to see our proposal for a modal ICD arbitration, whereby ICD, I mean intra-corporate disputes, in the eye of a pan-European approach. Also, I mean, from which also practitioners and people looking at the topic of specialized courts must take a look at. To some extent, we are very close, but opposite to what Casimiro and the other colleague from Germany said in the last panel. But we are looking at it from the eyes of the arbitrators. And in addition, we also saw that Professor Zorzi is going to join the conference later on next Friday, and we wanted to avoid any overlap. And eventually, and to conclude my very initial thought, we do not underestimate the importance of specialized courts. We're just making a case that arbitration might play a role, let's say a complementary role, supplementary role, with respect to courts. The presentation will follow, will develop as follows. So I will leave the floor to Valentina for presenting the case, and then we will just Valentina and I will just come back and forth presenting specific aspects of our presentation. The idea is to have the presentation a bit more dynamic than if one only speaker had spoken. So I'll leave the floor to Valentina.
Thank you, Federico. Thank you all for this invitation. We are very glad to present research and to debate this with you. We will start from a very briefly description of the Italian legal framework. In 2003, Italy enacted a comprehensive and balanced regime for intra-corporate dispute. And in doing so, it expressly allowed for an arbitration clause to be inserted in the bylaws and addressed and solved many of the issues that normally corporate arbitration face, such as what are the quorum to adopt a bylaw, an arbitration clause in the bylaws, how to define subject matter arbitrability, how to ensure that the appointment of arbitral tribunal is made in a typical multi-party dispute. The important thing to note is that this regime on intra-corporate arbitration was introduced in the general framework of the reform on company law, with the specific goal to enhance the enforcement of shareholder rights, to promote private autonomy in shaping internal governance arrangements of the company, included arrangement on dispute resolution, and to render the Italian system more competitive. However, there is also an explicit ban on the use of intra-corporate arbitration for listed companies. This seems quite contradictory for us because we argue that ICD arbitration is especially useful for listed companies since it can provide redress to shareholders and improve management accountability, enhancing the effectiveness of private enforcement of shareholder rights, and can trigger positive externalities in attracting foreign investment and promoting capital markets. Also, there was no clear reason why this ban was introduced because no explanation was given in the report which introduced the arbitration regime, nor there were clear obstacles in the general legal framework on this. The main reasons that scholars found to this ban are practical ones, normally related to shareholder minority protection needs and the cost of arbitration, which, in our opinion, can be easily addressed and solved from a regulatory point of view. So what are we suggesting with our paper? We suggest that the ban on arbitration for listed companies should be removed and in the meantime, specific rules addressing specific needs of listed companies should be adopted. And we suggest to adopt a model for intra-corporate dispute arbitration for listed companies in Italy, which should rest on the regime already existent that is quite balanced and good, and in introducing selected amendments just to address specific issues of listed companies. In proposing this model, we adopt three perspectives. The corporate governance perspective, and here the important thing is to ensure that minority shareholders are protected when the clause is inserted in the bylaws and that access to arbitration is ensured to all shareholders. And here we put a special focus on costs of arbitration. The capital market perspective, here we try to find, to strike a balance between the transparency requested by capital markets and the traditional confidentiality of arbitration. The third perspective is that of arbitration law. Here we see three main issues at stake: the appointment of arbitrators in order to ensure their independence, a better definition of subject matter arbitrability, and the empowerment of arbitrators with conservatory and interim powers.
Well, of course, hold on. Okay. Of course, when speaking of ICD arbitration, we must confront with some comparative pinch in order to understand the various different approaches around the world to these aspects. And I wouldn't say surprisingly, but realistically, we saw quite a debatable issue all around the world. Even though somehow there's a general consensus on the arbitrability of ICDs. However, some jurisdiction appears to disfavor agreements to arbitrate ICDs in public companies. We can identify, like for purely descriptive purposes, we can identify, let's say, three main approaches. On the one end of the spectrum, there are those countries among which the most famous one is Brazil, which mandate the corporate disputes be settled by arbitration. Even though Brazil, generally speaking, allows arbitration clause in bylaws of listed companies, but the listing rules of the Sao Paulo Stock Exchange do mandate the presence of such a clause. Close to this position, we see that those countries that basically allow but not mandate arbitration clause in listed corporations bylaws, such as Spain, or Sweden. Sweden also with a specific regulation on costs, on cost bearing, that we might get back to in later if we have time. On the other end of the spectrum, we have those countries which, on the contrary, expressly forbid for publicly held or listed company from adopting an arbitration clause in their bylaws. In addition to Italy, of course, as we just said, there are a bunch of other countries, such as Russia, by express legislation, or, if we're not mistaken, but the presence of so many important speakers to this conference coming from said countries might help us in let's say in assessing how true that this statement is, and therefore we'll get back to the guys from Spain or from the Netherlands and other countries in order to we'll liaise to them. We'll liaise with them in order to understand, to better focus our research. But anyway, pursuant to relevant court decision instead of express legislator provision, also the Netherlands has ban on ICT's arbitration for listed companies. And probably the most famous or most renowned case is that of US, which is where this topic has recently or has been traditionally, but most recently, but again, most recently has been a very debatable debatable issue, and their position is quite peculiar because, again, there are an interplay between federal laws, state laws, and jurisprudence that makes this case very peculiar. But anyway, in between from these two radical positions, there's the vast majority of states where basically the stipulation of an arbitration clause is not explicitly banned, or in other words, is admissible. And among these states, of course, positions are different. And for example, there are those countries where essentially historically such disputes have traditionally being adjudicated in state courts, or where case laws such as France with UK, or such as Germany, where the jurisprudence, that the case law, has not yet ultimately resolved upon ICD's arbitrability for larger companies. However, this does not prevent, in practice, companies, quite big companies, eventually listed on let's say different stock exchange, such as the Royal Dutch Shell, whose shares are listed in the Netherlands, in London, in the UK, and in the US, from having a quite let's say well-structured arbitration clause in its bylaws, in their bylaws. Well, reasons for being skeptical, for forbidding such clause, may be country-specific. In Brazil, for instance, the reliance on arbitration stems from those law pays of Brazilian judges, or in conducting the proceedings, or good knowledge of corporate law issues. Whereas in the US, for example, at least our intuition is that, of course, protection of minority shareholders might be in danger, because the bylaws of a corporation might be amended by the directors themselves, who might then want to shield themselves from any sort of liability, preventing the more general and more traditional derivative and multi-party litigation, which is in the US at least, a well-functioning means of enforcing corporate governance and maintain market confidence. However, at a very general level, we might say that general reluctance seems to be grounded on public policy concerns, essentially relating to those points that Valentina was mentioned, and which in our view can be addressed by ad hoc rules. Then we might discuss whether at the legislative level or on a soft law basis, but still specific rules might address the main concern that most countries have, relating to, again, shareholders' consent to arbitrate, cost bearing, adequate transparency of the proceedings, and how to manage class actions and multi-party lawsuits.
So now we try to sketch what are, in our opinion, the main characteristics that the Italian model of ICD arbitration should have. And in doing this, we rely on what we already have in our legislation, and we suggest specific amendments just to make it work also for listed companies. First of all, we should address the issue of consensus principle and the protection of minority shareholder when including the arbitration law in the bylaws. Italian law already provides that the clause can be provided in the bylaws, provide for qualified quorum for the adoption of general meeting resolution, and acknowledge an exit right to those shareholders who did not consent to this resolution. Also, it explicitly affirmed that the arbitral clause is binding for all shareholders, existing and new shareholders. What do we need here? We need more transparency. Transparency on the proposal on the introduction of the arbitral clause when it is submitted to the general meeting, and in particular, it is important to indicate also what is the process under which the board of directors arrived to adopt this proposal. Once adopted, the clause in the bylaws must be disclosed in the relevant document of the company, notably the corporate governance statement. The second issue is that of access to arbitration. Here, again, the Italian legislation ensures a certain degree of transparency on the filing of the request of arbitration, which must be filed in the business register. So any shareholder has the right to know that an arbitration is ongoing. And the law explicitly acknowledges any shareholder the right to intervene in the proceedings once it's started. What should we add? We should add some rules on costs. And here we see two possible solutions. First, we can think about putting the cost of arbitration, charging the cost of arbitration to companies, totally or partially, and under certain circumstances. Here, the right balance to strike is not to encourage frivolous claims from minimum shareholders. The other one is to allow retail shareholders not to be bound by the arbitral clause. In this respect, they could be free to choose whether to go to court to file their suit or to go to arbitration. In the capital market perspective, as we already mentioned before, the balance to reach is between the transparency requested by capital market and the confidentiality of arbitration. We have seen that Italian law already requests the filing of the request of arbitration in the business register. Here we suggest that more transparency should be ensured, and the disclosure should be ensured also for the final award and for any other relevant step in the procedure. Finally, some indication on the arbitration law perspective. First of all, the appointment of arbitrators and their independence. Here again, Italian law allows and ensures this independence because the appointment must be made by a party outside the company, so no conflict of interest inside the companies in the appointment of the arbitral tribunal. We suggest that in the case of arbitration in listed companies, the arbitral tribunal must be always composed by 3 members. We also suggest that in case of listed companies, we must resort to an institutional arbitration. Here, if we have an institution administering the arbitration, we can be quite sure on the level of independence of arbitrators, on the predictability of costs, and on the general appropriateness of the whole proceedings. Again, the other two issues are subject matter arbitrability and interim powers of arbitrators. Subject matter arbitrability is defined in Italian law relating to the notion of disposable right. The notion of disposable right is quite uncertain in Italian case law. That's why we suggest to allow the arbitrability of any dispute relating to corporate relationship, dropping the reference to disposable right. Any dispute relating to corporate relationship has a patrimonial nature, and in that way should always be considered disposable and so arbitrable. The other issue is that of interim powers of arbitrators that right now are only acknowledged in a limited way to arbitrators. They can only suspend the effectiveness of a general meeting resolution. Instead, we suggest that broad powers should be conferred to arbitrators to be able to adopt interim and conservatory measures in any case. These are the main characteristics in our proposed model that should work for the Italian listed companies, and we propose to export eventually also at the European level.
Yeah, exactly. So this is, again, the part that follows is now really open to contributions from panelists and audience to this conference, because we somehow argue that ICD arbitration, again, has two fundamental characteristics in our view, or should have two fundamental characteristics. Should not be mandatory in the sense that a company can opt in to this mechanism, meaning that if it does so, it might do so consciously, because it believes that it is beneficial for the company itself, and again, it might be complementary to the idea, which is the core of this conference, of a specialized course. However, and why so? Because there are plenty of literature that suggests that creating an EU level specialized company law court could be beneficial for EU, because it could offer great speed and expertise, and lower error rates in the face of complexity, and be an alternative, or let's say again a complement to harmonized substantive corporate law. However, the reason why, or most of the reason why this hasn't happened so far, is that is twofold, at least. First, the fact that Europe is different from the US, and there cannot be or there cannot have been yet a Delaware-like court. Is that because in the US the law of incorporations is always applied, and here instead of the home country rule, which is applicable in the EU. And on the other hand, a practical difficulty is that the developing effective judicial systems may take a while. So even though we purport this idea, we're not sure that this might be a resort in the short term. As such, generally allowing ICD arbitration for listed companies in EU might be beneficial, or should be beneficial. Also because opting into ICD arbitration clause, or into ICD arbitration, could also have signaling effects, because might allow well-intentioned corporations and entrepreneurs to send credible signals that they are committed to limit private benefits or extracting private benefits. And this might end. I mean, even though we're not suggesting necessarily a European legislative initiative, we are also of the idea that these might be addressed, or in any case, be let's say subject matter of a debate, also through the means of soft law, and develop at the level of academic initiative and also self-regulation. But this is our latest thought about that. We think that ICD arbitration might also serve what is as being emerging in the very recent past as one of the main objectives of EU company law. If we think of the Shareholder Rights Directive, the second, of course, we see that it is emphasized there the importance of shareholders' engagement in conjunction with long-term commitments, which combined should lead to better corporate governance. Well, that said, then shareholders who might be more lenient or might face less hurdle in suing a corporation by taking active role in ensuring board's performance and accountability, might serve that goal, might serve that objective, and provide alternative route for preserving governance values. Again, litigation has not traditionally been a way for institutional investors to show their engagement, but probably, this is our intuition, probably if we allow them to be to have resort to this mechanism, this might also be a way to show engagement and serve the purpose of better corporate governance. Thank you for your attention, and Arek, the floor is yours again.
Thank you so much, Valentina and Federico, for this thought-provoking presentation. And I hope we will have a chance to discuss this in the final discussion round. But as the structure of the panel is such so that we first have the three presentations, and then we will come together to discussion. So please let me now move to the next speaker. Maciej will be the next speaker, and I think his talk will be a nice bridge between the topic that you covered, namely arbitration and lessons from arbitration to professionalization of resolving corporate disputes. Maciej's focus will be on expert witness. This is a problem that has been raised many times during today's conference, and he will look at this taking into consideration the experience of arbitration on the one side and also of the common courts. On the other side, what are the similarities and what are the differences when it comes to the involvement of expert witness? And this is therefore a very nice bridge, because our last speaker in the panel, Krzysztof, will be focusing on precisely on the topic of expert witness and his role in the common courts. So Maciej, you are very nicely suited here to connect those two topics. And having said this, please, the floor is yours.
Thank you very much, Arek. First of all, I hope I am audible and visible. I see on the screen that my PowerPoint is on, so perfect. Great. So thank you again, Arek, for inviting me and for the ability to participate in this panel among such distinguished practitioners and academics. And I too, as Professor Rafael, feared that I come from, let's say, the enemy camp. So arbitration as opposed to capital market and commercial court system. But in fact, my role today is not to advocate in favor of arbitration over capital court system. But by the way, I'm a great advocate of arbitration in general. My task today is to compare two traditions, a Polish tradition, Polish approach to expert witnesses, and the role of expert witnesses in international arbitration, to see what are the best features for the commercial capital market court system. So we all know that in common law tradition, expert witnesses usually give oral testimony. This is the basis, this is the principle, and they are also in principle party appointed. So party is offering witness evidence as an element of presenting witnesses. In civil law, the tradition is different because we usually have written opinions and we usually have tribunal court appointed experts, and those two words collide. I would like to discuss briefly today, first of all, what is the notion of expert reports under Polish and arbitral law. We're going to touch upon the typology of expert opinions. But what is important for me is to show how crucial and significant expert opinion may be under Polish and arbitral law. We're going to discuss other than arbitration and state court litigation means of dispute resolution, which might be also helpful in giving a food for thought or developing a good system of dispute resolution of corporate disputes. I prepared also some empiric studies on the use of expert opinions. And finally, we're going to discuss effects in decision making and procedure related to experts as grounds for challenging state court judgments and awards. And this would allow us, first of all, to compare advantages and disadvantages of two systems, and finally make some final conclusions and recommendations for commercial capital market system. So, starting from the notion of the expert opinion, and under Polish law, there are little definitions. Law requires expert evidence when the court has specialized knowledge, but actually don't know what this specialized knowledge is. There are definitions proposed that we are talking about above average specialist knowledge in a given field of science that exceeds knowledge of the general public. But there are equally no lists of fields that require specialized knowledge. And why is that important? Because as we will see in a minute, if the case indeed requires specialized knowledge and the court fails to adduce expert evidence, this might lead to setting aside, to changing its decision. Well, there are equally no detailed legal definition of expert opinion. There are also no list of formal and substantive requirements of an expert opinion. This, in turn, leads to the result that many different opinions in different courts in Poland differ. Of course, certain kinds of opinion, for instance, evaluation of real estate, has some legal requirements stemming from different sources, but other opinions might lack the common ground in establishing what such an opinion should contain. Also, there is no legal definition of an expert, but of course, such a person needs to deliver special knowledge. What we know is that experts under Polish law are not witnesses, and in principle, they should not testify as to facts, save for some exceptions, for instance, in expedited proceedings. But equally, they are not court employees. They are not on the payroll of the court, but still they are commissioned by the court, and they get remuneration from the state, from the court. And this is again an opposition to the common law tradition, where the experts are remunerated by parties. The experts under Polish law can be recruited either from a list of experts or appointed ad hoc, but Polish law does not differentiate the status of such experts, or for good, as long as they deliver specialized knowledge. But interestingly, and as compared to the international arbitration, only a physical person or a group of persons can become an expert, so not a company. However, Polish law contains a different notion of a scientific institute which can deliver opinion in complicated cases. But this is only a margin of cases, because we are talking about, according to the statistics I found, 3% of opinions. So, like we said, expert opinions pertain not presenting facts, but to evaluating facts. Equally, experts do not give their witness evidence on law. However, there is an exception for foreign law. Polish court can adduce evidence, expert evidence pertaining to foreign law, if foreign law applies to the case, and this is quite often an issue. And any lawyer with background in different legal system can serve an expert here. The experts, like we said, help court to evaluate facts and help in decision making. However, they will not help if there is not enough evidence to support the claim. But they may help the court realize that the claim is unsupported. And I can give two examples from my practice. First of all, the court, after receiving an expert report, realized that there is no causal connection between allegedly tortious actions of a party and alleged damage. And the court expressly said that report, which was supposed to compute the damage, actually made the court realize that the case should be dismissed. And second example, the experts can make the courts realize that the claimant or the respondent, depending on the burden of proof, did not support enough evidence, for instance, to calculate the loss. And this can also lead to dismissal of the claim. Another interesting issue is that the experts, when they lack some evidence, they quite often take the steering wheel and ask the parties to present some documents and engage in some sort of document production, which under Polish law is unregulated, unfortunately. So the status of documents that are presented with an opinion but do not have been previously presented as evidence is actually questionable. We still have no firm case law of that. A lot of authors argue that such evidence, such documents cannot be basis for decision making of the court. However, the parties may obviously file them separately. But even if the expert would not help the court in reaching the decision, a Polish legal system contains some sort of a safety valve that allows the expert, the court, to award damages, for instance, in appropriate amount that is totally up to the court to decide, when it would be very difficult or obviously pointless to compute the damage. Then you would probably wonder, because we were talking about tribunal or court-appointed experts, what is the role of party-appointed experts under Polish law? Well, it is minimal, because under jurisprudence of Polish courts, the expert report, the notion of expert report, pertains only to report of a person that was employed by the court on the basis of evidentiary order. So we're talking about the label of an expert only with respect to tribunal or court-appointed experts. So a private opinion, private report, can only serve as a document or a reinforcement of parties' position, and therefore, as compared to expert evidence given by a court-appointed expert, the evidentiary force of such evidence is minimal and limited. And the case dramatically changes under arbitral law. Obviously, the law, and I'm talking here primarily about UNCITRAL model law on international commercial arbitration prepared by UNCITRAL in the 80s, and all the legal systems that base their arbitral laws on that law. Those laws usually also do not contain definition of an expert report or an expert, but model law expressly allows tribunal-appointed experts in Article 26. Despite the fact that the model law does not touch upon the issue of private opinions, private appointed experts, most or all authors accept party appointed expert evidence under a general rule allowing party to present the evidence. And also, what is important, arbitral law, as in many aspects, require the parties to be treated equally and give them ability to present their case. And that is why any evidence, in particular expert evidence, should be also presented to the parties. The issue of expert is further discussed in arbitral rules. Well, because the model law does not talk much about or none about party-appointed experts, those rules usually allow them explicitly, and also underline, which is a basic principle of arbitral law, the influence of the parties. So the parties have the deciding voice on how to shape the evidentiary proceedings, including the expert evidence, and this will be important for our further discussion. Moving forward in the sphere of arbitral law, after discussing the hard law, meaning law and arbitral rules, we also have quite a lot of soft law instruments, and I would like to talk more about two of them. We have, known to most practitioners, IBE rules on taking of evidence in international arbitration. And the rules, which are very popular, widely recognized, and forming basis of many arbitrations, they mention explicitly and give detailed rules on both party and tribunal-appointed experts. Well, in the rules themselves, there is no preference given, but a lot of authors accuse, let's say, IB rules on preferring party-appointed experts, and that was the reason for adoption of Prague rules. But we're gonna reach them in a second. And as IB rules discuss party-appointed expert in detail, they set forward requirements for expert reports, which is important. For instance, the experts must outline the methodology, evidence, and information used in arriving at the conclusion, which is important, which is not always the case in Polish based tribunal-appointed expert reports. And also, they solve the issue of the documents. For instance, it happens quite often in Polish litigation that the expert opinion is based on some documents that the expert obtained from the parties but not disclosed them. Here, under IBE rules, there is an obligation of an expert to disclose all documents that form the basis of the report. However, which is also quite interesting and gives some sort of a chance to attack IBE rules. The IBE rules do not require the report to be correct or to be truthful. In Article 5, Section 2, subsection G, the rules require the expert to present, I quote, an affirmation of his or her genuine belief in the opinions expressed in the expert reports, as opposed to the truth. And this touches upon the issue of so-called hired guns, so private experts being advocates of parties and not impartial and independent court assistants. We're gonna get there in a minute as well. And this critique was a basis for preparing another document a couple of years ago called the Prague Rules. Prague Rules, as opposed to IBA rules, which have a general international character, Prague Rules are based on a civil law tradition. So the tribunal-appointed experts are preferred in arbitration under Prague Rules. However, party-appointed experts are still possible. Also, what the Prague Rules tackle is the critique towards party-appointed experts, namely the so-called ships passing at night. So two opinions of expert witnesses that are completely different and have nothing in common, and therefore make tribunals' case very, very, very difficult because the two reports are uncomparable. So the Prague Rules allow the tribunal to impose, first of all, witness conferencing, expert witness conferencing, or joint report of party-appointed witness, and that should help with that issue. Of course, there are other soft law instruments. For instance, the Chartered Institute of Arbitrators prepared a protocol on the use of party-appointed witnesses, which is a good example on how to tackle formal requirements, the independence of private experts, and it's very useful. Going on with the presentation, of course, we have different types of expert opinions. We have written and oral, and written are usually used in Polish courts, but usually courts also call the expert witness to the stand. We have the main opinion and supplementing opinion if the parties are discontent with the first opinion. We have an abstract opinion, for instance, opinion on the issue of law that does not generally touch upon a given case. And we have a concrete opinion that deals precisely with the case at issue. We have party appointed, we have tribunal appointed, individual experts, we have group of experts, but all of them important under Polish and arbitral law. Why? Because, as we touched upon previously, an expert opinion under Polish law cannot be replaced by any other means of evidence, so witnesses, documents. No, only you can, as a party, use an expert opinion from other proceedings, since a couple of years ago, after the law was modified. So this means that the court can appoint an expert upon a party motion. It can do so even without such a motion. But what is the most important, it even has to appoint an expert witness, even when there is no such a motion, when the case requires special knowledge. Otherwise, as we will see, it risks its judgment being set aside. On the other hand, if the case does not revolve around special knowledge, the court cannot or does not have to appoint an expert witness. And this is completely different in arbitration, because the role of experts in arbitration is not so formalistic. The experts assist parties in presenting the case and assist experts. So I can imagine, and I saw that in arbitration, that the tribunal appointed an expert witness just to do the maths, just to compute the numbers that was stemming from the facts of the case. This is not a specialized knowledge. Everyone can use Excel, but it's obviously possible in arbitration. So the expert reports usually or often relate to issues that do not require specialized knowledge, and quite often they relate to legal issues where the arbitrators are not familiar with a given legal system or applicable law. And like we said, here the party autonomy is crucial, as stated by the Polish Supreme Court. Parties in arbitration can even decide that the expert witness evidence is not required at all. Or they can decide that the parties shall submit their own party-appointed expert reports, and the tribunal will not appoint a tribunal-appointed expert. They can agree on tribunal-appointed expert. So sky's the limit, and what is important is that their autonomy should, and their voice should prevail. And what also prevails in practice are private party-appointed expert opinions. Why? Because they usually allow the dispute to be resolved quicker. And the timing issue, despite the critique of modern arbitration, is one of the issues, one of the reasons why parties actually select arbitration over the state court system. But not only arbitration is connected with expert evidence, we have also an expert-oriented means of dispute resolution that go beyond the state court system. First of all, for those familiar with the FIDIC rules, we have dispute adjudication boards. So panels of experts, usually engineers, sometimes lawyers, but mostly engineers, that are deciding on parties' disputes not after the contract was implemented, but during the implementation of the contract, and usually within very short deadlines to keep the construction site running. That's very important for the construction industry, but quite often those dispute adjudication boards are used in different industries, for instance, IP. And we have also expert determination, for instance, under the rules of the ICC, International Chapter of Commerce. So in cases when parties need the expert opinion in their ordinary case of business while implementing the contract, but also if they are negotiating or they are on the verge of a dispute, they may adopt expert determination. However, the expert determination of the parties so decide may be binding upon them, but this is not an arbitral award, nor it is, of course, a state court judgment, so they have to go to court to arbitration to enforce their rights stemming from such a report or document. I've given a bit of a theoretical background, but let's see how does this operate in practice. So I've got two reports on the use of expert witnesses in Poland. We have a Helsinki Foundation Human Rights and Polish Business Roundtable report of 2014, quite a long time ago, but believe me that I believe that the findings are right still. So obviously, remuneration for experts should be higher. Experts are underpaid. Courts should have more powers to discipline experts because they usually don't present their opinions on time. There should be a general list of experts and not a list of experts in local court that would allow the courts to reach for either the best experts or the experts that can actually do the opinion, prepare the opinion on time. And obviously, despite a direct legislative basis in Polish law, parties do not always have a say at the appointment of experts, and they should have a deciding voice here because it's their case, after all. We have also a Justice Institute report of 2016, and it gives some ghastly numbers. So first of all, average time for the main opinion is 70 days, which is not that bad, 2 months. But if the parties are discontent with the opinion, and it's mostly the case, the average time for the supplementary opinion in Polish court is 200 days from filing of the main opinion. So we've got 270 days, almost a year, just for the expert report, let alone discussing other evidence and hearing witnesses. So in 50% of cases, the experts were late with the reports. What we will see in an example in a while, in 90% of cases, after the parties commented on the witness reports, the experts did not change their stance in any way. Obviously, the report repeated some other arguments, including the argument about the general list of expert witnesses. But let me give you an example I found recently on one of Facebook page for Polish lawyers. A lawyer came back from the court and was very tired about the situation and asked what to do. So he was hearing an expert witness in a case pertaining to costs of construction work that was not done by the construction company and had to be commissioned to other company, and the costs of such commissioning were in question. So the expert should have given the court numbers. So what construction of a home, of a house, how expensive it is, and what are different positions on the list. One of the positions on the list was plastering, so putting a plaster on the wall that you can see in the picture. So the lawyer learned from the report that the expert witness, instead of computing the cost of the area of the wall, actually computed the volume of the room. So as if the construction company would fill the whole room with plaster instead of just putting plaster on the wall. Obviously, it made comment in writing about the report. The expert said that everything's perfectly fine. It even came to the hearing to question the witness, but the case was taking so long that the court, either knowing there's something wrong with the opinion or not knowing, but wanting to conclude the case quickly, just made the final judgment using the numbers given by the expert that were, of course, exorbitant, because he made a silly and simple mistake that is quite easily visible to every one of us, even here, not having expert knowledge. But this example gives you, in a nutshell, the problems of Polish court system and experts. So the experts are underpaid, the quality of the work is sometimes low, but the courts are also unwilling to change something as long as they have a number that they can base their opinion upon. They wash their hands and not intervene. But as far as examples are concerned, or surveys, I also made a survey on my LinkedIn. So just to confirm, which seems to be obvious, and it is obvious to many dozens of our friends and practitioners and academics. So I asked them, in terms of the effectiveness of the report, which kind of a report is more effective for arbitrators? And you see that nearly 80% of the stakeholders said that the court or tribunal appointed expert report is better, more reliable, probably. Whereas the numbers are reversed if we ask which expert report allows a party to more effectively present the case. Obviously, party appointed expert opinion. Also, we asked about the costs and time, and as long as the party appointed expert allow the parties to save time, 60% said so. Also, 60% of respondents said that the court tribunal appointed expert can save costs for the parties. We'll see whether this is particularly true, because I'm not sure if the respondents taken into account the so-called shadow experts opinion. And finally, we ask if there would be one model of expert evidence allowed. You see that nearly 2/3 of respondents said that they would welcome court and tribunal appointed expert witness system and resign from party-appointed systems. And this gives a bit food for thought, especially for the commercial and capital market court system. So we're gonna reach that in a second. So you have a background, you have a good overview of two systems, and you've probably seen that in Polish litigation we have underpaid and overburdened experts that present their expert opinions very late. And we have a limited chances of the experts to combat parties that are refusing to cooperate, despite Polish courts being able to impose or join adverse inferences. But on the other hand, we have a reliable, impartial, and inexpensive opinion. Of course, this does not take into account the cost of some so-called shadow opinions or shadow expert opinions. So that in most cases before Polish courts, if the stakes are high, a renowned law firm would probably hire a private expert to help lawyers to evaluate the tribunal appointed or court appointed experts' work, and this also adds costs to both of the parties. In terms of arbitration, we've already said that we have party appointed experts that usually do not have to present an accurate opinion, but opinion based on their belief. So they're called hired guns. We also have a problem of opinions that have nothing in common and are comparing totally different things. We have the issue of costs, and especially legal aid issues. So in arbitration or in a dispute resolution system that operates under the assumption of party-appointed expert witnesses, a party may not be able to afford an expert at all. On the other hand, we have tribunal appointed. I see, Arek, that my time is running up and I'm wrapping up my presentation. And we also have to tribunal appointed experts an accusation of being de facto arbitrators. But on the other hand, this all allows to resolve the dispute quickly. Let me quickly pass to final conclusions and recommendations, and leaving the defects in decision making maybe to other discussion. So we got, when adopting a court model for commercial and capital market disputes, we have a first model that operates under the assumption of tribunal or court appointed opinion as the only or the primary source of expert evidence. This is of course a civil law background and has some drawbacks: time, quality, but it equally has some advantages: costs and control of the court or tribunal over experts' work. And we have a second system. Let's call it Model B, where party-appointed experts become either the only or the primary source of expert evidence, and it is common law background. And here the drawbacks and advantages are reversed, are opposed to Model A. So we have costly opinions that are not being controlled by the tribunal, but they are delivered quickly and the quality is usually high. I would be very happy to hear your thoughts about this system. I just think that some of the issues that are regarded as drawbacks of the Model B can be easily overcome, and I'm leaning towards the second system, contrary to what was stated by the stakeholders in my survey. But like I said, I'm very happy to hear your thoughts, and thank you very much. Thank you very much for the floor, and hope to engage in a discussion afterwards. Thank you.
Maciej, thank you so much for sharing with us this perspective. as I mentioned in the introductory talk, you have a lot of experience, hands-on experience, and I hope in the discussion we will be able to. What you said, much of this has a general nature, and I hope we will be able to narrow it down to corporate and capital market aspects. Now, since we are lagging behind time, and we have our last speaker in today's series of talks and also for this panel, but I am thrilled to hear his presentation, because the track record of Krzysztof and his perspective is hugely interesting, I think, because he will share his knowledge as one of the highest in demand witness experts in Poland, called by the courts to deliver opinions on mostly financial instruments, and has experience both in civil litigation and also criminal litigation. So Krzysztof, I am certain I am not the only one who is very much looking forward to your presentation. We are all looking forward, so the floor is yours.
Okay, thank you very much. So I will try to be short, but I would like to begin with some comment to Professor Piotr Stanisławiszyn presentation during the previous panel. He told us that that specialized court should exclude criminal cases from its recognition. Then in the discussion he has corrected himself that maybe not at the first stage, because those criminal cases are much more difficult than civil cases. So in the second stage, maybe we should include also those criminal cases. And in that, I do agree with him, because I'm giving opinions mainly in criminal cases, but also in some civil cases. And the typical opinion in criminal case takes me 100 to 200 hours of hard work. The shortest one was 20 hours. The longest one, which took me almost a year of hard work, it was over 1,200 hours. So it's not easy, not an easy task to prepare the opinion in such a way that the judge can understand what is in that opinion. So let's start with definition of market manipulation. We have regulation of European Union, well known as MAR, Market Abuse Regulation. And there's a delegated regulation, Commission that delegated regulation, which in Annex 2 specifies 86 very detailed entries. And those entries are very detailed, but they are still so vaguely defined that it's very difficult to understand them for people who are not experienced in that business. The next problem is that in Polish law, those criminal sanctions are provided not in one act of law, but in two acts of law. Law on trading in securities, it's about market manipulation and inside information. And the second act of law on public offering, which deals with prospectus and inside information also. In both cases, the sentence may be up to about €1 million or up to 5 years in prison, or both sanctions applied together. Well, Maciej has explained us that there's no central list of expert witnesses, and that's a real problem because there are 46 registers at 46 regional courts in Poland, and each of them has its own list of expert witnesses. And there's no real definition of the fields of expertise. So I have studied all those lists that are accessible at the internet and counted 18,078 expert witnesses in all different fields. But after elimination of double entries, it makes some 17, maybe 18,000, because some experts are specified in different fields, so that they are specified twice or even more times in one list, and some of them are listed in several registers. But when I tried to calculate how many expert witnesses we do have in securities trading field, and they are registered only at 12 regional cards. So 34 cards have no expert witnesses in capital market, in securities trading. And there's an extremely small total number of no more than 18 expert witnesses in that field. I have written here no more than 18, because when you read the description, you can only guess whether they are expert in that field or not. And half of them, 9 expert witnesses, are registered in Warsaw. So you already can see here the specialization of Warsaw. There's a need for experts in that field only in one city in the capital of Poland. There is a specialized prosecutor office. All market manipulation cases that are identified by Polish supervision authority, KNF, go to one specialized department at the regional prosecutor office in Warsaw. Then the prosecutor transfers the case to the police. There is a specialized department at the police metropolitan police headquarters of Warsaw. And then such a police department asks an expert witness whether he can prepare an opinion. And there's the one problem, because the expert witnesses are paid very small amount, but the police has even less money, so that they have to ask 3 candidates for how much their opinion will cost. The police has the obligation to choose the less expensive opinion. So just at the start, the police has to choose the expert who declares that his opinion will be the worst one, because he will use very short amount of time for preparing the opinion. Sometimes they have a special acceptation from the chief, from the prosecutors of central prosecutor office to ask for the more expensive opinion, not for the less expensive. But the problem still exists. But after the case is prepared, it goes to the court according to the place of residence of the defendant. So it does not go to the court in Warsaw, but somewhere in Poland. So in theory, a judge in such a court has to assess whether an expert witness opinion is reliable, and to pass a sentence based on his judge adjustment of the case. But in practice, a judge that does not understand the business aspects of the case. And my role, very often, I have to teach the judge what the case is about. So how the judge can assess whether my opinion was reliable on the basis of the knowledge he has just acquired for me during the sitting. So in practice, an expert witness opinion in such cases is automatically converted into court sentence, which is very bad. And I would like to show you one example where if you can see something on a diagram, but when you study the diagram exactly, the real picture is quite totally different from that picture that is that is prepared by an expert using the Excel worksheet. There's one case of manipulation. It took a long time, several sessions, but here is one case from one session where investor called XX was buying shares, that blue dots, and selling shares, those red dots. When you look at it, he was buying shares at the average price. He was buying shares on that during that session was 960 zloty, and he sold those shares at the average price of 10 zloty 10 groszy. So, well, it's quite okay. This is the role. You should buy shares cheap and sell them at higher price. Then you have some earnings. But when you look here at those lines, the first hour was he was raising up the price. The second 2 hours he has stabilized the price. Then he sold the shares, and then he was buying shares at the higher price. But finally, when you look, the price of the shares was not going higher than 11 zloty. But let's study that small area of 75 minutes. Now we can see the diagram for those 75 minutes. And you can see the price was about 10 zloty for almost all the time, and twice for short periods it raised up to 12 zloty. But that period of price at 12 zloty was for just 19 minutes. Then a period when the price was lower was only 29 seconds. And then for almost an hour, the price was remained still very high. But when you put that diagram in a real-time perspective, you will get quite a different picture. So you can see that for almost all the 75 minutes, the price was very high at 12 zloty limit. And only for 29 seconds, the price went down when that investor was selling shares. So the real picture is that, and what is even more important, that he sold 1,900 shares, but he kept the price of shares at very high level, with 9 shares before and with 20 shares after. So this is a typical example of making very wrong impression when other investors look at the price of the shares. They believe that there's something who is buying shares for 12 zloty, but in fact he's not buying shares at 12 zloty, but he's selling shares at 10 zloty. So what are dangers and irregularities? The Dutch has no tool for assessing reliability of the opinion of the expert witness. The case is not set by the court, but by the expert witness, but with no practical and legal guarantee of his impartiality and his independence. What is even worse, the expert witness is burdened with a full responsibility for the court sentence. What is even worse, that responsibility means that if I make an unintentionally false opinion, so if I make a mistake, not an intentional, I can receive a criminal sanction of 3 years in prison. Well, this is very dangerous for expert witnesses, and I can easily understand why nobody really wants to be an expert witness in such a situation. And what is even worse, that the defendant is deprived of real pledging rights. So, in my opinion, the only solution is to have specialized court or courts, maybe in the beginning for civil cases, but finally it has to include criminal cases also, with judges qualified enough that an independent body, maybe the court, that specialized court, should be able to assess qualifications of expert witnesses. The central register of expert witnesses, and but with real tools for monitoring of their experience and qualifications, because now anybody can become an expert witness in capital market cases. No diplomas, no papers are required. If I go to the court and say, well, I want to be an expert witness in capital market cases, and the court is so happy that he writes me into the register. And impartiality of those witnesses is not monitored now. Independence sometimes, when the parties claim that the expert witness is not independent. And what is finally, only in such an organization, education and training system could be performed, but not only for courts, not only for prosecutors, not only for police, but also for expert witness, because all the knowledge I have earned is my experience, my personal experience. I have had no lectures, no trainings. I had to come to that expertise by myself. Well, thank you very much. Well, that's all.
Krzysztof, thank you so much. You are known not only for your competence and expertise in the capital market and financial market, you are also known for always adhering to the schedule. So I appreciate also that you were able to cover this in a time provided. So with this, we are now ready to open discussion. We will have a chance to exchange ideas in the forum, but also if there would be any question for every panel so far, there have been some questions from the audience. I will be looking there if there are any on the Facebook, but I also saw that more people were following us on YouTube than on Facebook. But if there are some questions, I will also read them loud. Please let me start with a joke, because much of this panel has to do with trying to draw a line between what the court should understand and where this knowledge ends and where special expertise is needed that is brought by the expert witness. And this joke is as follows. We have three actors on the stage, an eyewitness, an expert witness, and the judge. And the eyewitness is a person that saw everything, but understands nothing and decides about nothing. Then we have an expert witness who didn't see anything, but understands everything, but still decides about nothing. And then we also have a judge who didn't see anything, doesn't understand anything, but decides about everything. And I think with your presentation, you contradicted this truth stemming from this joke, because as you know, jokes usually convey some truths in a very funny way. So the truth here has been, I think, quite convincingly contradicted, Krzysztof, by your presentation, that actually boils down to a very bold statement. The one who renders the judgment is the expert witness. I have a couple of questions to all the speakers, and Enrico, I don't know if Valentina is still with us.
Yes, I'm here.
Okay, you are both. Okay. My first question would be, the topic of this conference are specialized courts, and we see arbitration as just an alternative and a part of the broader context. The question would be, assuming in the audience we had an Italian Minister of Justice, and he would like to have some takeaways, not for reforming arbitration law, but to install a specialized court modeled maybe after the Dutch Enterprise Chamber or maybe after the Israeli one. Would installation of such a court make the room for arbitration in Italy redundant, or would it not? This would be my first question. So, or putting it differently, is your call for extending arbitration to listed companies only valid as long as there is no state court, or you would consider this independent ideas?
Actually, I would consider it independent. And in Italy, we have specialized courts for business disputes. We see arbitration and traditional court as complementary, and we would like to enhance the possibilities offered to investors and companies to solve their disputes. Also, we believe that it depends very much on the structure of each company to decide to have an arbitral clause in the bylaws. And we see especially use of arbitration in smaller issuers, probably listed on alternative markets, such as a small SME growth market, where less shareholders are in, more professional investors are in. So they might be more interested in this kind of dispute resolution mechanism. So I think that the two systems should coexist.
If I may, I basically share this view. Even though I see where you're coming from, Eric, and I might say that generally speaking, that might have that effect. That is having specialized courts deciding in a timely manner would definitely help enhance the system and possibly reduce the tendency, the tendency of investors to go to arbitration. But I agree with Valentina. They should be complementary. They are not mutually exclusive. But again, for example, I would say that Italy might look closer to Brazil in that respect, in the sense that in the absence of proper institutions, it is better to have arbitration.
I see. Another question is maybe for the sake of proper understanding, because the general term that you were using were corporate disputes. Now, to make sure, because this very notion still might be quite broad, even if we are talking about specialization, if we are trying to focus on a narrow field, this narrow field is not as narrow if we look closer at this. We might have some disputes where the number of parties is rather limited. It obviously might affect a larger number of parties, but the very number of parties directly involved is limited. If you have a dispute that stems from an M&A transaction, if you have a dispute between a buyer and the seller about the title transfer, about whatever claims based on warranties and representations, there the number of parties affected is rather clear. But in continental European countries, where you have rather, in many companies, if you have rather concentrated ownership, much of the shareholder litigation is about challenging these resolutions by the general meeting. This is an experience quite different from the one made in Anglo-Saxon countries, where most of the disputes are between the managers and the shareholders as a group. So there, in a listed company, you have hundreds of thousands, if not millions, of shareholders. I would like to make sure that in your proposal, you would like to embrace this category of claims as well.
Yes, we would, of course, include this. The issue here is, on one side, at least according to Italian legislation, any shareholder can intervene in an arbitration we started by another shareholder. But clearly, one should reflect on the idea of class action and if it can be imported in the arbitration system.
And
yes,
thank you.
Yeah, go ahead.
Yeah, you wanted to add something, Federico?
No, just once again, the thing is, it might result in a practical issue. We do not see any ontological hurdle in admitting that. Of course, arbitration is not the exact substitute for specialized courts, and we're not claiming that investors should only go to arbitration, or arbitration is the only resort for assessing and adjudicating corporate and, I would say, securities law disputes. And for that reason, we say that it is just a matter of carving, of tailoring ad hoc rules in order to adjust that tool, that mechanism to the bigger audience, as in a multi-party action.
And my final question to the presentation by our Italian colleagues would concern protection of minorities. You mentioned in your presentation that the cost could be a problem, and we want to avoid a situation when the cost is prohibitive. Do you have any ideas how would you internalize this cost? We have some experiences from derivative actions in different countries have different cost rules, and the idea is basically the same. If there are some minority shareholders pursuing a goal that should be seen in a way as a goal of general interest as well, there are different rules that shift the costs between the plaintiff and the company. So is it something that you would consider as a model also for the cost rule on when it comes to arbitrating corporate disputes? And another subcategory of the wider problem of minority protection would be, now think of a day we have this, right? So this is the day zero when the companies, listed companies in Italy, can opt for arbitration clause. Now, with the very day they decide to do so, there is something that is changing for the company. And correct me if I'm wrong, but it seems to me that for non-listed companies in Italy, whenever you implement an arbitration clause, it triggers an exit right. It triggers an appraisal remedy for dissenting shareholders. So would you consider the same for listed companies as a means for protecting shareholders when you change the regime of rights enforcement?
First of all, on costs, yes, we suggest that costs could be at least partially charged on company, but under specific conditions. And we would like to avoid the risk of frivolous claims. And in this respect, we may think about linking the costs charged on companies to the fact that the request for arbitration is not manifestly groundless, and also if it is filed by shareholders representing a qualified percentage of share capital, especially if we say that retail shareholders may always go to ordinary court. As to the exit right, yes, in this model, we keep the exit right also for listed companies. Actually, this should be a major obstacle in introducing such a clause, and we can think over and more deeply on this specific aspect. I want to add just one thing. We say that companies may be charged of cost for the exercise of right from shareholders, but it also happens in other parts of company law. If you think about shareholder identification, in Italy we have a rule which allows minority shareholders to ask for shareholder identification, and in this case, companies can be charged of the cost itself. So it is not a principle which is not known in our system. So we can refine it, but it can be used somehow.
And also, if you let's say if we develop, if we build a sort of institution, arbitral institution that I would say oversee, or let's say organize or help organizing the corporate disputes arbitration, that might intervene also on costs. I mean, the fees of the arbitrators might not be enormous. There might be some standard market standards on how much an arbitrator should be paid. For example, depending on the value of the controversy, for example. I mean, so this is clearly an issue, the issue of costs. But either costs might not result in such a huge amount, or we can find some sort of mitigants. But again, it's a matter of decision. It's a matter of rules that can be established.
And if I may add one last thing, also litigation in court is costly. You don't have the cost of arbitrators, but you have the legal fees, so it is costly. And from the company perspective, probably to be able to have a decision in shorter time might well justify the charge of partially of the cost of arbitrators.
Yeah, it's a sort of trade-off.
Yeah.
Thank you for the questions.
Yeah, thank you for addressing those questions. This is very insightful. Thank you. If we might move forward now, we had two presentations that presented like different angles looking at the problem of expert witness. And Krzysztof, you presented some numbers telling us that the percentage of expert witnesses that have competence in trading with securities is rather small. But in order to have a better idea, we should also take into account the number of cases, because clearly the number of cases based on securities trading cannot be compared with, say, traffic accidents. And it comes at no surprise that you have way more experts on traffic than you have on securities trading. So what is, if this small number remains in relation in a way with the number of cases? And well, this would basically be a question that would in a way supplement these figures that you were just presenting.
Yes, the number of cases is really small. There's very difficult to get strict numbers, but as the procedure for selecting an expert witness is so as I described, I believe that I see almost all the cases that are directed to the prosecutor by the KNF. So it's about 15 to 20 cases a year. There are also some cases where courts asks me for an opinion, but I believe that it's no more than 20, 30 cases per year. That's another reason why they should be concentrated in one place, because with such a small number of cases, there's no sense to educate all the judges in Poland in that field. Because the probabilities, simple probability says that those educated judges will not receive the case. But there's another problem is with the small number, those 18 expert witnesses is not enough, because as I can assess by my experience, only 2, 3, maybe 4 expert witnesses from that number of 18 are really good experts. So I have several cases when the opinion waits for me. Now, when there's the question whether I can prepare an expert witness opinion, my answer is yes, but no earlier than in 2023. Well, that's the answer. We are lacking not only experienced judges, but we are lacking the number of expert witnesses.
Thank you. I have a question that is addressed to both of you, Maciej and Krzysztof. And well, the problem comes up all over again, the dividing line between what is expert knowledge and what is basically knowing the law. Are there any cases from your practice or whatever other experiences or knowledge you might have where it was in a way challenged, because if the court asks an expert witness and the expert witness comes up with something that should actually pertain to the understanding of the law rather than some technical or whatever as knowledge, it could be then, for instance, challenged on appeal that the what has been delivered is not about this very knowledge, because there are at least two fields where this dividing line is blurred: intellectual property and financial regulations. Because whenever we have medical malpractice, whenever we have traffic accidents, whenever we have problems with construction, then it is rather clear to differentiate between what is this technical special knowledge and what is applying the law. But whenever it comes to the patents, for instance, intellectual property, or whenever it comes to financial instruments, it is quite difficult. So is there anything that you could say from your practice where this has been in a way mixed up?
Well, it's very often because I am often when I am called to the court, the most typical question is, well, you say this was a manipulation, but what is a legal ground for that? Then I have to take out that MAR regulation and that delegated regulation, and read those 86 entries and explain why one specific entry applies to that case. So I have to explain the law and apply the law to the specific case. And it should not be my role, but there's no other way. Because the judge, I can remember half a year ago when I was called to the court, and after my examination by all the parties, the judge thanked. The judge told, "Well, I have to thank you. I have to thank the expert witness for such a great lecture, because only after that I do understand what the case is about, because when the parties explained the reasons, I could not understand anything."
Maciej, would you like to add something to this?
Well, I don't have any particular case, but I have a general comment that indeed quite often the line between the law and the expert evidence is blurred. But what is even more important is that even if we raise those arguments, it's very difficult to convince the court that the expert opinion is flawed, for instance, because it discusses law instead of facts. Why? Well, it is some sort of a paradox, because Polish case law, under Polish case law, the fact that the party is simply discontent with the expert witness's opinion is not sufficient for an appeal. On the other hand, you cannot question the expert witness report without expert specialized knowledge. So it's a paradox, and that's why it is very difficult to succeed on the appealed based merely on the attack against the expert witness's opinion. So that would be my first comment. The second comment is that those issues are maybe redundant in arbitration when the party's autonomy is prevalent. So the parties may agree on the scope of the opinion, and they also can agree that an opinion might cross this line, so that some legal arguments will be given by experts. As long as the parties are happy about it, why not? The only risk here is that there is a case from Supreme Court and earlier Court of Appeals in Wrocław in Poland, where this party autonomy was violated. So the parties agreed first on the party-appointed experts, and those expert opinions were unconvincing to the arbitrator. It was a sole arbitrator. And the arbitrator said that I'm unconvinced, and I'm going to probably appoint an expert witness, so a tribunal-appointed expert witness. And both parties agreed to that, and even motioned for that. But later on, the arbitrator changed his mind and ruled in favor of one party. And this award was set aside, not because you cannot base your opinion on party-appointed expert evidence, but because the arbitrator violated party autonomy, because parties agreed that there needed to be an extra opinion by tribunal-appointed expert.
Thank you. We have one, it is more a comment than a question from our colleague, Dr. Ariel Mucha, who will be the speaker, who will be one of the speakers next Friday. He says that the market abuse regulation is very specific because it is a translation of market practice into legal provisions. So no wonder that experts like Krzysztof must first explain what the law really means. So more comment than a question. Krzysztof, do you take notes? What is your success rate, more or less? How often does the court follow your opinion, and how often it does not?
So in this aspect, my record is very high, because I do not know any case where a court did not follow my opinion. Sometimes the defendant tries to argue that I'm not independent. In some cases, the judge decides well, so my opinion is dismissed, but not because it's their own opinion, but because there are some doubts. I doubt that those doubts, but this is the current decision. But I sometimes I have to deal with some wrong opinions. But I can remember only one case when the court has collected several opinions of expert witnesses. There were 3 opinions, different in the results. So I was asked for assessing the opinions of those experts. No, not really assessing, because it's not my role of that, but to determine what was the real situation. And all 3 opinions were mistaken in several very important details. All those 3 opinions were different. So they were dismissed by my opinion level.
Thank you. So from what you are saying, I could summarize. Above Polish judicial system, there are just 2 powers who are even higher. One of them is the Court of Justice of the European Union, and the other one is Krzysztof Grabowski, but only one of them is currently undisputed. We do not have more questions on the Facebook, but maybe you have questions that you would like to address to one another.
Well, I would have a lot of questions to Maciej, because he had no time to finish his presentation, but I believe that I will be able to see that the whole your presentation, and then maybe privately ask you all those questions.
With pleasure,
Under
obviously.
normal circumstances, please, Maciej.
Yes. I just wanted to confirm that it would be my pleasure to discuss it afterwards. And the same, of course, with Professor Raphael and Madame Malotti as well. I also noted some questions, but I would be happy to see the presentation in full and discuss them perhaps by email.
Normally, I would say this discussion could be continued in a less formal setting during a networking dinner, enjoying also a glass of wine, and there are really some good Austrian wines down here. I know I see the smile on the face of Federico because Italian wines are excellent, but believe me, there are some good Austrian wines here as well, very just nearby in Burgenland, and I sacrificed myself to do the selection, a demanding job, but I did it for the sake of post-conference dinners. But then the pandemic came, and well, we will need to look for another chance to convince ourselves. Since we are already slightly beyond the schedule, there is no place now for concluding remarks, and the main reason why is it not the time now? We are just halfway through, because we will continue next Friday, and after the conference that we hopefully will be able to hold on site, we will try to have first concluding remarks, but the real conclusion of the project will be hopefully a very needed book on that topic. There are not so many, and I think we get to understand better why, because the question is multifaceted, complex, and there is no obvious group of people that could work on this, because as we have people bringing expertise from different angles, different fields, but the topic in some countries is quite hot right now, and some other countries already have this experience that can share with us, and there is no better way just than the one learning from one another. So thank you to you, my panelists, and to everyone who spoke before, to all the chairpersons of the panels that we had before, for your questions, presentations, and for being with us in spite of this circumstances that are not as rewarding as if we could have a chance to meet afterwards. So thank you so much for your contribution now towards this conference, and I very much look forward to your contribution to our emerging book. And having said this, I would like to finish the first day of the conference and welcome, and I would like to invite everyone to join us on next Friday here in Vienna at the premises of Polish Academy of Sciences. Thank you and goodbye.
Thank you.
Thank you. Bye-bye. Arek, bring the bottle of wine next July in Rome, please.
This obviously, this I will do.